Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon,
Your Honor. Good afternoon, Your Honor.
All right. Reading my chat messages, which I fail to do sometimes, so I'm going to start out today and read a little bit. Let's see. We do have a conflict defender, Ms. Kim.
Yes, Your Honor. Yes, Your Honor.
Okay. 4, 15, and 17. Okay. Thank you for.
And Your Honor, I am entering in the chat as well for you.
Oh, okay. Let's see. All right. Let me.
Good afternoon, Your Honor.
Good afternoon. How are you?
I'm well. I'll be hosting the Zoom if you need me. It's
Yes,
Ms. Middlebrook.
Yes, ma'am.
Okay.
Okay, 1, 5, and 10. Thank you for that, Ms. Gant. All right. Are
You're
you able
welcome.
to see that? Does Ms. Bridgewater see that 1, 5, and 10 have waivers?
Yes, ma'am, I have them.
Okay. You all just updating me, so I appreciate it.
Okay.
All right, we'll get started. Any other announcements before I start? All right. Good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar for Wednesday, June 15, 2022. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before state court judge. So we're going to address several matters, including bond, possible arraignment, or consideration of a possible plea offer if one has been made by the state at this juncture. I'm going to also be providing individuals with the reset court date for arraignment or for the SAP calendar, state all purpose, which is June 30th. So our reset date for SAP is June 30th. I want to begin.
Excuse me, Your Honor. Let me correct that. That's going to be June the 28th.
Uh-oh. I'll take the blame. Did I get it backwards? Probably.
No.
Oh.
No, today is Wednesday. My schedule juggles, so we're still on the Tuesdays.
Oh, I got you. Okay.
Mhm. So that's going to be SAP reset date is June the 28th.
Gotcha. All right. Sorry about that, guys. All right. I'm going to begin by advising everyone, all the defendants on this calendar, that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want you to also be reminded that you have a constitutional right to have an attorney to represent you at this hearing, and I believe that that has been accomplished by most on this hearing. Also, I want you to know that you have a right to remain silent, that anything that you say about the facts of your case, the circumstances, or anything regarding your case, those statements can and will be used against you. Prosecutors are here. Be careful, govern yourself accordingly, and listen to your attorney when they tell you not to speak or make any statements that could be against your interests for later in the case. All right, where are we starting, deputies?
Stop Annex. Good afternoon, Your Honor.
Good afternoon.
I have position number 22 in front of you, Ms. White.
Okay. All right, this is case number 22 CR 003821D. Antica White, you're charged with one count of simple battery family violence. The offense date is June 13th, 2022. Good afternoon, pretrial.
Hey, 6 total. Last was 2018 cruelty in the second. It was reduced to reckless conduct conviction. 2017 ag assault reduced to simple assault conviction. 2016 battery against a female who is pregnant. That was dismissed. 2016 trespass arrest and a 2013 simple battery dismissed. That's it.
Thank you. All right, Ms. Duncan, how are you?
I'm well. How are you, Your Honor?
Good. You may proceed.
This offense occurred on June 13th, 2022 at the location of 551 Utoy Circle, that's UTOY Circle, Southwest in Atlanta. The victim in this case is Darius Nunn, the defendant's legal spouse. Darius is Darius, Nunn is Nunn. In this incident, Your Honor, there was an altercation between the defendant and the victim, Mr. Nunn, in this case, where the defendant in this case, Ms. White, grabbed Mr. Nunn's shirt collar and began to pull him, which caused him to fall down on the ground in front of their house, Your Honor. When he fell down on the ground, his cell phone broke. And after he fell down to the ground, Your Honor, the defendant proceeded to pick up a bottle of antifreeze and water, or just antifreeze, I wasn't sure, from the warrant, and throw it at the defendant. The warrant indicates that the antifreeze bottle did hit the defendant in the back. And he began to run away from her at that time, Your Honor, to try to de-escalate the situation. And she continued to follow him, and again, threw that same jug of antifreeze at him again. Additionally, Your Honor, we have a concern in this case about intimidation of the witness. During my research, I noted that this same victim filed a warrant against his wife in 2020, which he subsequently dismissed of his own accord. However, we're concerned for his safety in the cycles of violence. Given this defendant's violent history, there are violent convictions in this case. We are requesting a $2,500 surety. No further contact with the victim in this case. If there are any children, we would ask for third-party contact, stay away from the incident location, one-day anger awareness, and no alcohol, drugs, and weapons.
All right, Ms. Kim, is this your case?
Yes, Your Honor. Ms. White is, she is 29 years old, and she was born and raised here in Georgia. She has 6 minor children. Not only her husband, her parents and siblings, entire families are here in Georgia, and he has a job at beer supply company. So she has a strong ties to the community, and therefore she's not a flight risk. She graduated from high school, and pretrial services actually recommended her for unsecured judicial relief. So we would like to request for a signature on bond, Your Honor. Thank you.
Pretrial will defer to the judge.
Yeah. I was gonna say, I don't see that, but thank you. All right, Ms. Kim, thank you for that. All right, did we find out, are there any of the minor children? I know you spoke of.
Yes,
Duncan.
there is one minor biological child of the 6 that is the child of the victim and defendant in this case.
Okay.
Yes.
All right, I'm going to order the $2,500 surety bond. I'm going to order that there be no further contact with the victim, Mr. Darius Nunn. I'm going to order that if there's to be visitation or exchange of the children between the parties, that there be a third party to do that exchange so that, Ms. White, you don't violate the conditions of your bond. You're to have no further contact with Mr. Nunn at this time. You are to stay away from 551 Utoy Circle Southwest. You to find an alternate source of housing. I'm going to order the one-day anger awareness course. And no drugs, alcohol, or weapons while you're on bond.
Your Honor, can she have one-time visit with law enforcement officer to retrieve her personal belongings?
All right, I order a one-time return to that location with law enforcement. Please do not go back by yourself, Ms. White, or you can possibly be arrested for violating the conditions of the bond. You can return one time with a police escort to retrieve your personal items. All right, anything else, counsel, I need to take up?
Nothing further from the state.
All right.
Nothing, Your Honor.
All right, thank you. Hold on
Thank you.
one quick second.
Your Honor,
Ms. White, judge has already ruled. If there's any question, I'll call you.
Okay.
Thank you.
All right, who do we have next?
position number 12, Your Honor.
This is case number 22 CR 003838Y. Looks like Rakia Lipscomb, you're charged with one count of criminal trespass and damage to property. The offense date is January the 8th, 2022. Pre-trial.
Second arrest, 2018 FTA, driving without a valid license. She's recommended.
All right, thank you. All right, Ms. Brown.
Good morning, Judge. Good afternoon, Judge.
Ma'am.
In this case, this incident happened at 216 Farron Drive in Atlanta, Georgia. Officer met with the victim, Jamari Gregory, who advised that the defendant, who's his child's mother, came to his residence very irate because he didn't get his children, I guess the prior weekend. She initially left, but then she returned and broke through the front door. The officer observed damage to the door and that it couldn't close and the latch had been broken. The recommendation in this case is a $1,500 signature bond, no further violent contact with Jamari Gregory, no alcohol, drugs, or weapons, one-day anger awareness.
Your Honor, we have no objection to signature on bond.
All right. I will order the $1,500 signature bond through pretrial. I am going to order that there be no further violent contact with Mr. Jamari Gregory. I'm going to order a stay away from 216 Barron Drive, one-day anger awareness course. And if there's to be any more visitation with the children, that be done through a third party. Does she need a one-time escort to return to that property?
I don't think so, Your Honor. She actually moved out from the location.
Okay,
They don't live together anymore, Your Honor.
okay. So there will be no reason, Ms. Lipscomb, for you to return to that address.
Yes, Your Honor.
So stay away from 216 Barron Drive. No drugs, alcohol, or weapons while on bond. And the one-day anger awareness course. All right, anything else I need to take up, council?
Nothing from the state, Judge.
Nothing further, Your Honor. Thank you.
All right, thank you.
Everything else out there.
I'm sorry.
Um,
Position number 3 is next, please.
This is case number 22 CR 0038, excuse me, 3827C. Micaiah Cook, you're charged with 1 count of criminal trespass, a 2nd count of simple battery family violence. The offense date is June 14th, 2022. Pre-trial.
Second arrest, 2021 theft by receiving felony out of Cobb County. Appears to be open.
All right, Ms. Harmon,
Yes, Your Honor. Good afternoon.
good afternoon.
Let me just pull up Ms. Cook's.
Okay,
The offense date, Your Honor, appears to be June 14, 22 at the location of 11440 Johns Creek Parkway in Johns Creek, Georgia. The victim in this case, her name is Kashia Kelly, and I'll spell that. It's Caieisha, last name Kelly, Kelly. The parties do live together, Your Honor, and they were apparently in an argument about a cell phone in the parking lot in that address. And at one point, the verbal argument did become physical, and the defendant struck Ms. Kelly multiple times on her body by punching her. The defendant also hit the windshield of Ms. Kelly's car, leaving a large crack in the windshield. We do believe that she is a danger to the victim based on the incident detail, and there hasn't really been any cooling off period here. Thus, our recommendation for the criminal trespass is a $2,000 surety bond. And for the simple battery, it's a $2,000 surety bond recommendation. No further contact with the victim, a 1-day anger awareness course, no alcohol, drugs, or weapons, and to stay away from the incident location or where the victim, stay away from the incident location and no further contact with the victim. Nothing further.
all right, thank you. Ms. Gant,
Thank you, Your Honor. Ms. Micaiah Cook is 17 years old. She has been in the Atlanta, Georgia area for the past 2 months. She does not have any family here, Your Honor. We are opposed to the stay away. If the stay away occurred at my client's current address, she informs me that she and Miss Kelly are roommates and that she does not have any place to go. I did speak to Miss Kelly, and I understand that she is present on the Zoom call. Miss Kelly informs me that she wants to continue having contact with Miss Cook. Miss Cook completed the 11th grade. She informs me that she was an A student. However, she left school because of some issues with her family. I did have the occasion to speak with Miss Cook's grandmother, who is her guardian, and she informs me that Miss Cook is basically, she was an A student while she was in school. She did not have either her father or mother in her life. Miss Cook raised her. Your Honor, I am requesting a signature bond on Miss Cook's behalf. She is unemployed, Your Honor. She does not have the means to pay anything toward bond. I do acknowledge my client's history. However, I did not hear about any convictions specifically for violence. Therefore, again, I am requesting a signature bond. Her grandmother is willing to co-sign a bond for her. She does live in Illinois. And again, we are opposed to the stay away and the no contact orders. And if Your Honor determines that she is ineligible for a signature bond, then I would ask for a total bond of no more than $1,000, and that would be $500 for each count. Thank you, Your Honor.
Your Honor, we would continue to ask that you keep these parties apart and order them to have no further contact. Your Honor, what's concerning is that this was an argument about a cell phone that got violent, and it was damage to property. So that's just indicative of a high degree of anger and intensity between these parties. And I would hate to put them together again, and then we wind up here again behind another incident or a disagreement between the parties. So I would ask that you would keep them in a no further contact status at this time.
And Your Honor, if I may, these are allegations. My client is presumed innocent. She denies the allegations. And again, Ms. Kelly is available to speak to her wishes for contact, Your Honor. Thank you.
All right, is Ms. Kelly on the Zoom?
Yes, I'm here.
All right, I would have to see you, please. Can you put on your video? All right, do you wish to address the court today, Ms. Kelly? Unmute yourself. I can't hear you.
Hear me now?
Do you wish to address the court today, Ms. Kelly?
Yes.
All right, raise your right hand for me.
Huh?
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. What would you like to state about this incident, Ms. Kelly?
The incident, it wasn't about just a phone. It was a disagreement. I honestly don't have a problem with being around her at all. I feel like, honestly, when it's crazy because the only time it got violent was when others were around. But when we came back out, it wasn't violent at all. Like before the cops came, it wasn't violent at all.
Okay. How old are you, Ms. Kelly?
I just turned 21.
Okay. All right. Any cross-examination questions, Ms. Harmon?
No, Your Honor.
Ms. Gant?
Nothing further, Your Honor.
All right. And Ms. Gant, I understand that the defendant is 18?
Your Honor, she is 17.
17?
Yes, Your Honor.
Okay. And the grandmother, and I don't know her name, lives in Illinois?
Yes, Your Honor. It's Marcia Cook, and I have her contact information that I'm happy to provide in the chat.
So is she in town now?
She is not, Your Honor. And she informs me that she is Ms. Cook's guardian, legal guardian.
But she would have to sign her out. I'm assuming she's over 25.
Yes, Your Honor, she is.
So what I'm going to do, I'm going to order this $4,000 signature bond through the jail. But the conditions of the bond are going to be this, Ms. Cook. You are to have no further contact with Ms. Kelly. You are to stay away from 11440 Johns Creek Parkway. You need to find alternate housing or somewhere else to live. You're to take the one-day anger awareness course. You are to have no drugs, alcohol, or weapons while on bond. My concern is that your grandmother, I guess, needs to get here to sign your bond. Oh, I'm sorry, I did a signature bond. I apologize. But I am concerned that the two of you will not have any contact while you're on bond so that there will be no further incidents. Can you do that?
And Your Honor, if I may request a one-time law enforcement escort.
All right, I'm going to allow a one-time law enforcement escort for you to return back to the property. Do not go back by yourself, but you will need to arrange for law enforcement to escort you back one time to get your personal belongings. All right.
Judge, will you break that bond down, please? There are two charges.
I'm sorry, 2,000 each, 2,000 on the criminal trespass, 2,000 on the simple battery,
Thank
total
you.
of 4,000 signature bond through the jail.
Thank you.
All right, anything else I need to take that?
Nothing further.
Nothing further from the defense. Thank you, Your Honor.
Thank you.
Position on 15 and next, please.
This is case number 22 CR 003833J. State versus Crystal Morris. Your charge is 1 count of harassing communications. The offense date is October the 29th, 2021. Pre-trial.
6 adult arrests. Last was 2021 out of Florida. Battery DV. It was non-pros.
That's my case, Judge.
All right.
2012 DUI suspended license. Failed to appear from 2011. Those for suspended license as well. 2010 suspended license and the FTA for suspended license in 2009. She had a California arrest, but I think it was a juvenile arrest. That's it.
All right, Ms. Brown.
Yes, Judge. Although this happened in October of 21, I believe she was just arrested on it on June 14th of 2022. The victim in this case, Tyrell Lewis, informed me that he had received telephone calls from the defendant, totaling about 25 calls on that day between the hours of about 11 a.m. and 6 p.m. meant for the purpose of harassing him and some threats, Judge. Our concern in this case, well, let me go back. Our bond recommendation is $1,500 surety. No further contact with Tyrell Lewis, no alcohol, drugs, or weapons, 1 day anger awareness, stay away from 250 Far Road. And the recommendation is a surety bond, Judge. As you've heard from pretrial, I believe she's a flight risk at this time, Judge. She has history from, I believe, Florida and something from California. The most recent arrest from Florida was just in 2021. In addition to having those arrests from other states, Judge, you've heard that she has multiple FTAs. So our concern here would be that she would be a flight risk. And as you know, Judge, part of the consideration for bond is to ensure that she would come back to court. So we believe $1,500 surety would be sufficient in this case to ensure that the defendant returns to court. And that would be our recommendation, Judge.
All right. Is it Mr. Murphy?
Judge, I'd like you to consider a signature bond. My client was born and raised in Los Angeles, California. She's a college graduate. She's age 38. I believe she's been in Atlanta since 2007. We've only heard testimony about driving offenses and perhaps the lack of punctuality therein, but no crimes of violence. This is an alleged incident from back in October. The alleged victim is Tyrell Lewis, which was a former boyfriend on or before that time. My client has long since moved on from that relationship. I didn't hear any testimony that Mr. Lewis advised or had said that the phone call should cease. So I don't see where we've reached the threshold of harassing communications. My client is employed. She lives in Johns Creek at 4938 Rosalia Road in Johns Creek. She is on that lease. She does not work with Lewis. She does not have any children with Lewis. She does not have any social or church or any social events where she would run into him at. I'd ask you to consider a signature bond. She does not have any discernible assets at this point to draw down on. I'm going to have to reach out to her father. I'd ask to consider, given the time frame, to consider a signature bond therein. Again, there's been no evidence of violence, and any other thing on the radar screen's been related to traffic offenses, Judge. Thank you.
Mhm.
Judge, if I just may respond briefly.
Yeah.
Judge, I hear counsel mentioning that a lot of these are related to driving offenses. The consideration of flight risk is not so much what the charges are as it relates to the failure to appear, Judge. I believe a failure to appear, whether it's for a driving offense or any other offense, is a concern for bond. And if she's not attending court for whatever matter, that is considered a flight risk. In this situation, 25 calls. I believe there were also allegations that she had called his mother and had been talking to his daughter. And so that in and of itself is harassment, Judge. I don't think he would have okayed her to call him 25 times to speak to himself or his mother and his daughter, Judge. The arrest out of Florida, I believe, was for a battery in 2021, although it may have been dismissed, but that is from 2021 again, which is indicative of her being a flight risk. And so we think that 15 surety is sufficient. She's not a good candidate for a signature bond, and so we would ask that you leave it as a surety, Judge.
Judge, I would only add briefly that I believe that the alleged victim here is a defendant in a case involving my client. So I'd just like to consider that under the circumstances, but I'd ask for a signature bond there, and Your Honor, she does have a stable address.
All right. I'm going to order a $1,500 surety bond. I'm going to order a stay away from 250 Far Road. I'm going to order no further contact with Terrell Lewis. No drugs, alcohol, or weapons while on bond. And the 1-day anger awareness course. And I think that's all I need to take up at this time. Anything else, counsel?
No, thank you, Rod. Thank you, Judge.
Thank you.
Nothing from the state, Judge.
Okay.
Sorry, Judge. How much was the bond again, please?
1,500 surety.
Thank you. I have position number 16 next, please.
Okay. All right, this is 22 CR 003825E. Kayla Poole, you're charged with 1 count of theft by taking. Offense date is January the 14th, 2020. Pre-trial.
First.
All right. Ms. Duncan.
Yes, Your Honor, this incident did take place on January 14, 2020. However, the state is well within its right to prosecute, given the statute has told, due to the pandemic that we've been in, we are within our time frame to be able to prosecute this case, Your Honor. And although GCIC did indicate for us initially that this defendant was a first-time offender, however, upon further research, I have located that this defendant actually is in dormant bench warrant status for some 2016 charges from a case that is 17 CR 012354E. In 2016, it was a disorderly conduct and a giving false information charge. In addition to that, because of those charges, the defendant has a failure to appear from 2017 for plea and arraignment in front of Judge Morrison. So this would actually be the second arrest that I could find. In this case, Your Honor, it took place at a Jason's Deli located at 3755 Carmia Drive. That's CARMIA Drive Southwest. And this defendant is alleged to have stolen $360.01 from the register at Jason's Deli. In this case, we are concerned about this defendant's flight risk, given that this defendant has been in dormant bench warrant status and was currently out on a warrant for discharge for almost 2 years. We're concerned that she would not return to court. Given those facts and circumstances, Your Honor, we are requesting $1,000 surety bond, a restitution or fine to be paid to that Jason's Deli of the amount alleged by the victim in this case, which is $360.01, and no alcohol, drugs, or weapons.
Okay. How much is the restitution again?
$360.01. That is the amount alleged in the warrant to have been taken from Jason's Deli.
Okay. All right. Ms. Kim, I'm sorry. Yeah.
It's okay, Your Honor. I would like to, this is, Miss Poole is 24 years old. And actually, she has one child and she is expecting a baby right now. She's pregnant for about 2 months. So she's been going through a lot of nausea and the early pregnancy situation right now. And it seems like there was a huge misunderstanding with new manager on this Jason's Deli, where she's been working there part-time while she was having a full-time job at Staples. She will get a call. She has a on-call position to help out during the busy seasons like holidays and busy time during the weekends. And she was helping out the job. And I think there was misunderstanding with the new manager who is no longer familiar with her yet. So we would like to request for a signature on bond as pretrial services also recommended for. She graduated from high school and she is expecting to go to Atlanta Massage School from July 6, 2022. And she really needs to get out of the jail and take her prenatal vitamins, Your Honor. Thank you.
All right. Okay. I'm going to order the $1,000 signature bond through jail. I'm going to order that she, I'm assuming she's not still employed at Jason's Deli, to stay away from there. 3755 Parmia Drive. So I order stay away from there. No drugs, alcohol, or weapons while on bond. She needs to pay back that restitution, $360.01. And I think that is all I need to take up. Anything else from either council?
Nothing further from the state.
Your Honor, can we pay $360 restitution only if she is found to be guilty?
Yes.
Thank you, Your Honor.
All right, if there's nothing else, that will conclude this matter.
Okay, Judge, I have position number 8 is next, please.
Okay.
Receive.
This is case number 22 CR 003824C. Ms. Heath, you're charged with 1 count of simple assault, 2nd count of obstruction of a law enforcement officer, 3rd count of criminal trespass, all with the offense date of June 14th, 2022. What do you have pre-trial?
7 total. Last arrest was 2020 FTA, possession of cocaine out of DeKalb County. 2020 DeKalb County, armed robbery, cruelty in the 3rd. I think that armed robbery is open. 2018 battery, she got probation for that. It was a battery and robbery by force. 2018 possession of cocaine, dismissed. Pled no load of criminal trespass. In 2016, carrying a concealed weapon, carrying deadly weapon at public gatherings. Those were dismissed from 2006. That's it.
Okay. All right, Ms. Brown.
Yes, Judge. On June 14th, Deputy Clark conducted a perimeter check at 185 Central Avenue, which is the Fulton County Courthouse. He made contact with Ms. Heath. She was sitting on a ledge there at the main entrance. He asked her to leave, and upon asking her to leave, she started to yell profanities and other things at him. He asked her to leave a second time. She had a cigarette that was actually lit that she was smoking, and she threw it at him, hitting him in his chest area, Judge. That's the basis for the charges. Our recommendation in this case is a $3,000 surety, Judge. Stay away from 185 Central Avenue, which is the Fulton County Courthouse. And I would just note, Judge, I mean, I know that there are interests on both sides of the courthouse, so I would just say 185 Central Avenue and the Fulton County Courthouse altogether. No further contact with the officer, no alcohol, drugs, or weapons.
All right, and no further contact. What's the officer's last name?
Deputy Clark, Officer Clark.
Okay. All right, I'm going to.
Your Honor.
Yes, I'm sorry, Ms. Gant. I apologize. I thought of it at the same time. Please forgive me. Go ahead. One last question. Ms. Brown, you didn't give me the breakdown for those three charges. Is it 1,000 each?
Yes, Judge.
Okay. All right. Go ahead, Ms. Gant. I'm sorry.
Thank you, Your Honor. You were frozen for a moment. I am afraid that I did not hear the breakdown.
1,000 for each charge, total of 3,000. Surety bond is the state's recommendation.
Okay, thank you, Your Honor. Ms. Shaniqua Heath is 34 years old. She has been in the Atlanta, Georgia area her entire life. She has 5 minor children, ages 16, 14, 11, 9, and 3. Your Honor, we are opposed to the stay away at the courthouse. Your Honor, we would just like for her to be able to definitely attend court or be at court for any pending legal matters, Your Honor. Ms. Heath completed high school. She has a technical certificate in nursing. She is disabled and has been so for the past 4 years. Therefore, she does not have the means to pay anything toward bond. Your Honor, we are denying the allegations today, despite my client's history, based on her economic means and the nature of the allegations. Your Honor, I'm requesting a signature bond. She does have some issues with her living situation. We are connecting her to services to help in that regard. Your Honor, I again am requesting a signature bond if Your Honor determines that she is ineligible for a signature bond. I would ask for the lowest bond amount possible. And again, we are opposed to the stay away at the incident location, would ask for a no violent contact with the complaining witness, Deputy Clark. Thank you, Your Honor.
All right. And tell me again, as far as employment.
She is disabled, Your Honor. She has been disabled for the past 4 years.
She getting a disability check?
Ms. Heath, are you receiving a disability check? She appears to be shaking her head. Yes, Your Honor.
Okay. Yeah, I think they're muted. Okay.
However, she is homeless, Your Honor. So any resources she gets, we would need her to have those funds available to help with her housing.
Okay. I'm going to order a $2,500 surety bond. That will be 1,000 on the simple assault, 1,000 on the obstruction, and 500 on the criminal trespass, or 2,500 surety bond. I will not order the stay away, I guess, from the courthouse, but I will definitely say no further violent contact with Deputy Clark or any of the employees at the Fulton County Courthouse while on bond. No drugs, alcohol, or weapons uh, while on bond, and the one-day anger awareness course.
Your Honor, I do have concerns about my client's ability to pay for that one-day anger awareness course, and since this is not a pretrial services case.
Does anyone have any information on the cost of it?
I do not have any information on the cost of it, but she's not going to be able to bond out of jail, and she's not going to be able to pay that cost for that class, Your Honor.
All right, I'll remove the class, but I'll keep the $2,500 surety bond.
Thank you, Your Honor.
All right, thank you.
Position number 23 is next, Judge.
Okay. This is case number 22 CR 003831G. Gabrielle Williams, you charged with one count of theft of services. Offense date June 14, 2022. Pre-trial.
It's a third. Last arrest was last month. Criminal trespass. Before that was March, criminal trespass. So she got two open trespasses in state court. That's it.
Okay. All right, Ms. Duncan.
Yes, Your Honor, as pretrial stated, this defendant does currently have 2 open criminal trespasses with the Fulton County State Court. They're totaling of $5,000 total signature bond through the jail. In this case, Your Honor, this defendant went to the Lush Nail Bar located at 232 19th Street Northwest and got a slew of beauty services, including a pedicure, which was $67, well, $108 for the pedicure. Eyelash extensions, which were $45, and a full set of nails, which were $67. The warrant also, and the police report also do indicate that this defendant was attempting to get a tan at that time, but that service was not available. And then when this defendant was asked to pay, the defendant indicated that she was having trouble with her payment method or having issues with her card. The total value of services at the time was $232. The police report indicates that this defendant, Ms. Williams, became irate when security arrived and she attempted to exit the location. They asked that she contact her bank and advised that the bank advised her that there was no money in the account. And when officers asked her, did she have another method of payment or someone that she could contact? And she told them that she did not have another form of payment at that time. And at that point, Your Honor, this defendant was taken into custody for theft of services. We do have a concern about the risk of reoffense, given that this was a random incident and it's generally not prevalent to go into situations and you're not sure if you have the funds to proceed. In this case, particularly, they said there's no money in the account. So we're concerned that if she doesn't get the proper sentencing and situation here, that she'll go out and do this at another location. So we're concerned about the risk of reoffense here, given that, Your Honor, in her history with the 2 open criminal trespasses, we're requesting a $2,000 surety bond, a stay away from that location of Lush Nail Bar, and no alcohol, drugs, and weapons, as well as a theft class, Your Honor.
Your Honor, wasn't it $5,000 a signature on bond through jail? And then now state want to change?
No, let me correct the record. She has 2 open criminal trespass cases. Their individual totals add up to $5,000 signatures through jail. Those are separate and apart from this current offense.
Got it.
Okay.
Thank you. Your Honor, Ms. Williams is actually 28 years old, and she has 2 minor children, newborn baby and 3 years old baby. She's not married, so and she has not had any employment for last whole year. Currently, she has been staying at shelter. We are actually requesting social worker services on behalf of her so she can get housing resources. And she does not have any income sources right now. And we also want to have a behavioral health evaluation done for her through the social worker services. And that's what we are considering. And we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give her a signature on bond, only thing, probably maximum $500 surety bond. And if she is found to be guilty, maybe she can pay for that restitution later. Thank you, Your Honor.
All right.
And if I may, Your Honor, as the defense has so politely stated, this defendant has not been employed for over a year, and these services total $232. So we're concerned about a pattern emerging in this case, and we'd ask that the surety bond be set.
All right, I'm going to order a $2,000 surety bond. Gonna order stay away from Lush Nail Salon, 232 19th Street Southwest. No drugs, alcohol, or weapons while on bond. I'm going to order a theft class. I'm assuming that's a one-day theft class.
Your Honor, I'm afraid that she has no means to pay for that class.
Are we, is there still a, will you all be able to do a behavioral health eval?
Yes, Your Honor.
Let's see if she can go ahead and try to afford that theft class. I want to put that under the bond conditions. All right, anything else?
Will you all send me over the order for the judge to sign on that behavioral health, please?
Usually it doesn't require the order.
Yeah.
Okay.
It's not an MH, just behavioral
Gotcha.
health, right?
Okay,
So
thank
can
you.
Put that in the conditions that they will give a behavioral health eval.
Okay, no problem.
Okay, thank you. Anything else that I need to take up?
Nothing further from the state.
All right, thank you.
Thank you.
Mhm.
Good afternoon, Your Honor. This is courtroom 2. I have position number 19, Mr. Jeffrey Thomas.
All right. This is case number 22 CR 003819H, Jeffrey William Thomas, who charged with 1 count of DUI, driving under the influence of alcohol as safe, 2nd count improper turn, 3rd count of failure to maintain lane, all with the offense date of June 14, 2022. Pre-trial.
50 total.
How many?
50.
50.
Yes. Last arrest was back in April for shoplifting and obstruction out of Rockdale County. That's open. On probation for theft by taking.
Toussaint.
Yes.
I don't think that's him. It's position number 19. Jeffrey Thomas, Jeffrey William Thomas.
Hold on. Might have gave him the wrong one.
Need the booking number?
No. What's the date of birth?
July 10, 74, Your Honor.
July 10th?
Yes.
Yes.
State, what you got?
One moment, let me verify, because sometimes they update in the middle of court. So I have birth date, July 10th, 1974. And as far as the GCIC,
We'll roll with yours.
I have, let's see, what's this? I have a history, I only have a history out of, I believe it's Idaho, or yeah, I believe it's Idaho, I think, where there's 3 cycles, and there is a DUI conviction from 2016. In addition to that, I have a driving history record, which follows the citations from the other state. I don't have anything else besides that.
We can
Okay.
roll with yours. Whatever you got.
Okay, so in this case, Your Honor, this defendant does have a previous DUI conviction, but this, according to my research, would be his third offense under similar circumstances. The first one was in 2013. It was deferred. It was operating under the influence out of Idaho, I believe. And his driving history record contains citations for those offenses, as well as the corresponding suspensions at that time. Under these facts, Your Honor, it occurred yesterday on States Bridge Road and Metlock Road. Officers observed a car making a wide turn on Wilson Road onto Metlock Bridge Road going southbound. And after making that turn, that car was unable to maintain their position in that lane. The car continued to drift right in its lane, and the passenger tires were on the dash lines. Then that car made a U-turn on Statesbridge Road, and the tires continued to go over the dash lines, and the driver was not able, excuse me, to maintain the lane. At that time, officers initiated the stop and smelled an odor of alcoholic beverage emanating from the defendant in this case, Your Honor. The defendant declined the breathalyzer test. However, in the standardized field sobriety evaluation, this defendant showed 6 out of 6 validated clues on the horizontal gaze nystagmatism evaluation, 3 out of 8 clues on the walk and turn exercise, and 3 out of 4 on the one leg stand exercise. Given the facts and circumstances, it was the officer's determination that this defendant was driving under the influence, and that this driver did make an improper turn and was unable to maintain their lane. Given that this is would be the second DUI conviction on record, we request a bond in the amount of $4,000 total surety. That's $3,000 surety for the DUI less safe and $500 surety for the other 2 charges. We'd ask for no alcohol, drugs, and weapons, as well as restricted driving if a valid license exists, only to necessary destinations like work, attorney, court, and medical. Nothing further from the state.
All right, and give me that breakdown again.
$4,000 total. That's $3,000 for the DUI less safe and $500 for the improper turn and failure to maintain lane surety.
Okay. All right, Ms. Kim.
Yes, Mr. Thomas is 1974 was his birth year, and he moved from Iowa 1 year ago. He does not have a family members here in Georgia, so but he does have 2 people who he can trust that we can call out and ask for help. He has a ties to the community. He's not going to fly. He has a very stable job as a sales representative. He graduated from high school and he has an associate degree. We would like to request for signature on bond, and yet because of his previous DUI from 2016, if Your Honor is not inclined to give him a signature on bond, we would like to request for a total of $2,000, $1,500 DUI, $252 turn and FM failure to maintain lane for another $500, total of $2,000, Your Honor.
Your Honor, he also has two visitors. They're his neighbors here in the courtroom today.
Okay,
I don't think they were there at the incident location, so we would like to object to any testimony, Your Honor.
If I
Unless
may,
they were there.
If I may, Your Honor, any witness testimony may be helpful to the Ayala factor, so we would defer to the court. And I just wanted to, if I may, just say that we have a concern about risk of reoffense, as I stated before. Would be the third similar offense dealing with driving while under the influence, and this would be the second conviction of those three offenses. So we would ask that the state's request be granted.
all right. For those, the witnesses that are there, Deputy, they're neighbors, but I guess you can ask them real quick, did they have anything to add as far as the incident? They're just kind of character witnesses, I guess.
You guys want to say anything?
As far as the character witness, we spoke to the officer last night, right? We've had some celebratory events in the past.
Your Honor, I could bring him in.
Okay,
Okay. I need to get him back. Yeah, don't sit down.
But known that would address better, Your Honor.
oh, it's okay, I understand. Tell me your name, sir,
My name is Jeffrey Renfro.
and do you know anything about the incident that Mr. Jeffrey Thomas has been arrested for?
No, ma'am, I do not.
And you're his neighbor?
That is correct.
How long have you been his neighbor?
Almost a year now.
All right. So I guess you're gonna tell me he's a good neighbor, right?
Yes, ma'am, that's exactly what I was going to do, is that Jeffrey has been a very kind neighbor to us. We've asked for him for some help on a couple of occasions. I spoke to the officer last night and mentioned to him, right, that we had a celebratory, my daughter just graduated from high school. We had a celebratory dinner over there, and we offered him some beverages of alcohol content, and he declined that, which again, we're all home, thought it was okay, and just wanted to point that out from the What It's Worth department.
Okay. All right. Thank you very much for your time.
And thank you for allowing my voice to be
Okay.
heard. Thanks.
All right. All right, Mr. Murphy.
Judge, that's not my case.
Oh, I'm sorry. Oh, Miss Kim.
Yes, Your Honor. I just wanted to clarify that he was not at the incident. So I do appreciate his time to speak good about our client, and yet still, Your Honor, he was not at the accident scene or incident location, Your Honor. So we would like to request for the lowest possible surety bond if it has to be. Thank you, Your Honor.
All right. And with Mr. Thomas, what was the employment again?
His work,
Miss Kim?
yes, he's working as a salesperson, sales representative at the job. I do not have the name of the company, Your Honor.
All right. I'm going to order a $3,000 surety bond. The first charge DUI will be $2,000. The improper turn, 500, and failure to maintain lane, 500. So total $3,000 surety bond. I am going to order, obviously, no drugs, alcohol, or weapons while on bond. And no driving unless you have a valid driver's license from DDS. And is there anything else I need to take up, counsel?
Nothing further, Your Honor.
The state would just request that if it is in your honor's purview to limit the driving to necessary locations, being that this is the second DUI, Your Honor. In the alternative, we would ask for a defensive driving course.
Your Honor, those are for if he is found to be guilty. So I don't think that it is, I believe it is premature, Your Honor.
Right, I will not order the defensive driving course at this time, but I will say, usually what I do, Mr. Thomas, is say that you can drive to work, to see your attorney, or to go to court, and for medical purposes. And all the other driving should be limited or non-existent if you still have a valid driver's license. So of course, if you don't have a valid driver's license, which if and when you get out on bond, you need to double check that with DDS. If it's not valid, then obviously you do not or will not be allowed to drive and do ride shares or other means of transportation. But if you do have a valid license, let's limit it to work, doctor's appointments, and to visit your attorney or to come to court. Okay? All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Next, we have position number 11, Mr. Jones, D'Angelo Jones.
Okay. This is case number 22 CR 003829J. D'Angelo Jones, you're charged with 1 count of battery family violence with the offense date of 6/14/2022. Pre-trial?
This is fourth arrest. Last was 2017, operating while intoxicated. Hold on. Got a 2011 operating owner permitting another to violate motor vehicle code. This is out of Michigan. It's weird. 2003, got assault with intent to do great bodily harm. That was a conviction, 2 counts, and a felony weapons fire conviction. Yeah, that's it. This is first Georgia arrest. It's all Michigan. This is first Georgia arrest.
Okay,
All right.
thank you. All right, Ms. Brown?
Yes, Judge. This incident happened at 1716 Summit Springs Drive. When the officer arrived, they spoke with the victim, Arian Tyson, and she advised that they lived together. They basically had gone out that night. When they returned home, the defendant in this case wanted to go out some more to party. He asked her for the keys. She didn't want him to take the keys because she believed he was too intoxicated to drive. As a result, the defendant got angry and punched Ariana in the face. The officer observed a large knot on the victim's forehead. Our recommendation for bond in this case is a $3,500 surety bond to stay away from 1716 Summit Springs Drive. No further contact with Ariana Thompson. 1 day anger awareness. Although he doesn't have a very lengthy history, I think there was a prior DUI from 2018. There's another incident that involved alcohol on his record. And here we are again having another incident with alcohol, Judge. And so for those reasons and our concern about him reoffending and possible substance abuse, our recommendation is the 3,500 surety.
All right, Ms. Gant.
Thank you, Your Honor. Mr. D'Angelo Jones is 37 years old. He has been in the Atlanta, Georgia area for the past 2 years. He has family here, including a sister and a nephew. Your Honor, we are opposed to the stay away at the incident location. Mr. Jones informs me that that is in fact his residence. He is the leaseholder there. He wants contact with the complaining witness, Ms. Ariana Tyson. I did reach out to her. However, the numbers provided should indicate that the voicemail was not set up, so I was not able to get in contact with her. Your Honor, Mr. Jones completed high school. He also has some college credits in general studies. He plans to return to school soon to enroll in a mortuary science program. He is employed at North Metro Cocoa. He has Coca-Cola. He has been in that position since August of 2021. Your Honor, my client denies the allegations and I am requesting a signature bond. The report that I received indicates that he is recommended. I acknowledge my client's history. However, the assault conviction is 20 years ago. We have not heard of any convictions or involvement with law for violence since then. And of course, the driving offenses are nonviolent and the state references something about alcohol, Your Honor. These are allegations. Again, my client denies them and he's before you for battery, family violence, and not for any offenses relating to drinking and driving. So therefore, Your Honor, again, I'm requesting a signature bond. If Your Honor determines that he is ineligible, then a bond of no more than $1,000. And again, we are requesting no violent contact and that there be no stay away in place. Thank you, Your Honor.
Okay. All right, I am going to order a $3,500 signature bond through pretrial. I'm going to order a stay away from the 1716 Summit Springs Drive unless he returns there and Ms. Tyson has moved out. If he returns to that location, and he may want to take law enforcement with him, for that one-time escort and her things are gone and she is moved, then he can reside there. But if she is still there, he needs to stay away. And so Ms. Bridgewater will put a one-time escort to return to get his personal items. No further contact with Ariana Tyson. The one-day anger awareness course. No drugs, alcohol, or weapons while on bond.
And Your Honor, just so that we are clear, you are requiring a law enforcement escort to confirm that Ms. Tyson is no longer in the residence, correct?
That is correct, yes.
Thank you, Your Honor.
Next, we have number 21, Mr. Watkins.
21, okay. This is 22 CR 003837C. Is it Derek or Derek Watkins? You're charged with one count of criminal trespass with the offense date of June 14, 2022. Pretrial?
Your Honor, may I please, I apologize for interruption, but I would like to have a very short, brief breakout for this client, Your Honor.
Okay. Can you all put us in a breakout? Ms. Kim, Ms. Brown and Ms. Duncan both?
Myself and Ms. McCutcheon.
Ms. McCutcheon, okay.
Your Honor, good afternoon.
Good afternoon.
Judge, respectfully, I will not join the breakout room, Your Honor.
Okay, I understand.
You understand, Your Honor. I will not join the breakout room. But Ms. Duncan, Ms. Duncan, if you have any questions, you can please call me or email me.
Okay.
Thank you.
Thank you.
Nice to see you, Judge.
You too. All right, let's see if we get our notice on the breakout.
I will send a note to the host to let her.
Oh, Ms. Middlebrook, there she goes.
Okay.
Ted, I think you're muted.
I was gonna say Mr. Watkins is muted, but I was muted. I apologize. All right, can you hear me now, Mr. Watkins?
All on the back of his neck. No, don't do it like that. Yes.
Okay. All right, we're with your case, Mr. Watkins. You're charged with 1 count of criminal trespass. And I'm going to grant you a $1,000 signature bond through the jail. And what I'm going to do, Mr. Watkins, is you need to stay away from the 5 Points MARTA station. Can you do that for me?
Yes, ma'am.
Okay, because you've already been given a suspension from there through July 15th, but this may last a little longer with the bond conditions that you still can't go there. You have to seek other means of transportation, okay? Don't want you to get arrested again for being there, okay?
Ma'am.
And no drugs, alcohol, or weapons while on bond. Okay? All right, but stay away from the 5 Points MARTA station. I would say all MARTA, but I won't do that to you just yet. Is that your only means of transportation?
Yes.
Yes.
Okay, so I know that 5 Points is the major hub, but until we can get things sorted out and you're on bond, please do not go back to 5 Points, okay? All right, take care.
All right, thank you. Yes, we got number 17, Mr. Smith.
All right, 17. All right, this is 22 CR 003807Y. Antonio Smith, you're charged with 1 count of battery family violence. Offense date May 31st, 2022. Pre-trial.
Is this the reset from yesterday?
Yes.
I got it in the reset tray, Judge. I'll go get it unless you want the state to do it.
State can, don't worry.
Yes, Your Honor, this defendant has 2 arrests out of Kentucky and 15 arrests out of Georgia. This defendant is a convicted felon with arrests going back to 1990. This defendant has convictions from the 90s for drug-related offenses and entering auto. In addition, this defendant has an ag assault arrest from 2001. Additionally, Your Honor, this defendant has an open ag assault strangulation against the same victim in this case. That is case 22 CP 207016, and was currently out on a $30,000 good bond with a no contact provision for this particular defendant. In addition to that open ag assault case, this defendant has another open ag battery and family violence case out of Clayton County with a different victim. That case number is 2021 CR 01671. It's pending, as I said, in Clayton County for Judge Malone. But on that case, he was out on a $35,000 good bond with no contact with that victim and no other violations of Georgia law, and that was issued prior to all of these in October 2022. The facts in this case, Your Honor, is that the victim in this case, Deshaun Watkins, that's DASHUN Watkins, common spelling, called the police to report that her boyfriend had assaulted her at the incident location of 900 Sells Avenue. Sells is SELLS in Atlanta. She reported to officers when they arrived, Your Honor, that he had attacked her because he was upset that he had been arrested previously for assaulting her. That is where this altercation stemmed from, and officers indicated in that warrant that this defendant, one moment, Your Honor, I'm sorry, I don't want to continue. I know that yesterday this defendant said that he had a private attorney. I don't want to, is the attorney available? I don't see anybody on the screen.
Oh, I don't know.
Does he have representation?
Judge,
Yeah.
Judge, I was sent an email with him, but then I was advised by the jail that he has private counsel. So I did not interview him.
Ah,
And that's my apologies for starting my presentation before clarifying, but yes, this was the issue yesterday, Your Honor. This defendant said he had hired private counsel and they weren't available, and he requested to be reset to today.
okay, let's hold on for a second and see what we have here. Hold on. Did we get the name by chance?
No, I don't have the name, Your Honor.
Does he know who his attorney is?
Yes, ma'am. His name is Jonathan Malnick.
Say the last name again.
Malnick, Jonathan Malnick.
Yeah, now I'll try to reach out to him.
Is that Melnick?
Yeah, Malnick, that's how you say it. Jonathan Malnick.
And you have private counsel. Where is he?
I spoke with him a minute ago. They said they sent the link to him. I don't, whatever this link is.
Oh, they did?
They said, I don't know.
Miss
I
Mills,
spoke with him.
are you aware?
Ma'am?
Now I'm talking to the,
I'll try to reach out to his office, Your Honor.
okay. She's gonna try to reach out to him. We may have to hold for a second on you and do someone else and bring you back. If you have private counsel, that's who should be helping you with this hearing, okay?
We're gonna jump number 2, Mr. Brown.
Yeah. This is 22 CR 003835A. Mr. Brown, you're charged with 1 count of reckless conduct. 6/14/2022 is the offense date. Pre-trial.
What number is this?
Number 2, Jaleon Brown or Jaleon Brown.
I got first arrest.
Okay. All right. Ms. Harmon.
Yes, Your Honor, you already noted the offense date, and their location is 7360 Toccoa Circle. It's TOCCOA Circle in Atlanta. There were 2 victims that I identified in this case, Jada Ford and Howard Juper. Jada, last name Ford, and Howard, common spelling, last name Juper, JOOPER. Jada Ford was dating another third party, Kenneth Jenkins, and Mr. Jenkins allegedly sent Ms. Ford a threatening text message and then showed up to her home with 4 other men, one of the 4 other men being the defendant. Ms. Ford advised her father about the ongoing situation, and Mr. Juper, that's her father, arrived on scene. And when he arrived, he observed one of the males fire shots in the air several times. The defendant was observed fleeing the scene on foot. Law enforcement officers caught up with the defendant and advised that there were 2 handguns thrown over a fence, and the defendant admitted to hiding those weapons. Your Honor, our recommendation in this case is a $3,500 surety bond. No further contact with either Jada Ford or Howard Juper. Stay away from the incident location. No alcohol, drugs, or weapons. He's an obvious danger to the community based on the incident details, showing up to somebody's house, and then throwing guns in another person's backyard. Obviously, a child could have found them. God knows what could have happened. So that's the basis of the recommendation in this case. Nothing further.
All right. Ms. Gant.
Thank you, Your Honor. Mr. Jalen Brown is 19 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, and I've spoken to his mother, Ms. Jahari Brown. Your Honor, we are unopposed to the stay away. Mr. Brown recently graduated high school, Your Honor. He graduated from Langston Hughes. His mother tells me that he made A's and B's. He is a 3-star athlete. Your Honor, he has a scholarship to a bull ride, Division I D1 scholarship to play football at the University of Miami. He plans to major in biology. He plans to become a dentist. Your Honor, he is unemployed at this time. He does not have the means to pay anything toward bond. He denies the allegations. Your Honor, my client does not have any history of any convictions. This is his first arrest. He has a promising future. We do not believe that he is a danger to the community, being that he is presumed innocent, and these are in fact allegations. I am requesting a signature bond as he is recommended. Your Honor, if Your Honor determines that he is ineligible, I would ask for a bond of no more than $1,000. Thank you, Your Honor.
And he's 19?
Yes, Your Honor. And his mother certainly is willing to co-sign in any capacity if she needs to do so.
I don't think so, right? Pre-trial, since he's 19 and not 18.
Well, I don't usually take firearm charges. Those usually go through the jail.
He didn't get charged with firearm.
Oh, what was it, the reckless conduct?
Reckless conduct.
Oh, I didn't hear the conduct part, sorry.
Yeah, I wanted to order him through pre-trial.
Well, no, what is he charged with? Carrying concealed weapon?
No, I only have one charge of reckless conduct.
Right, we amended the charge from.
Oh, okay, I know the
the
booking
reckless.
sheet says carrying concealed weapon.
Right, we changed.
Okay, that's fine, okay.
All right, I'm gonna order $3,500 signature bond through pre-trial. I'm going to order no drugs, alcohol, or weapons while on bond. I'm gonna order a stay away from 7360 Toccoa Circle and no further contact with the victims Jada Ford or Howard Juper. And I'm gonna add on the 1-day anger awareness course. And I did say no drugs, alcohol, or weapons while on bond. I am concerned with the conduct, Mr. Brown, and I understand the weapons charge may have been dropped, but govern yourself accordingly while you're on bond. The pretrial will let you know what those conditions entail. Good luck to you at school.
Thank you, Your Honor.
Okay.
Number 14, Mr. Martinez.
It's 22 CR 0038336H. Martinez, charged with 1 count of failure to yield to right of way to vehicle. 2nd count driving hit and run. 3rd count duty of driver to stop at or return to the scene of an accident. No insurance. Is that a 4th charge, or that's with charge 3, or just 3? How many charges do we have?
There should be 3.
3. All right. The no insurance was stuck in there, so I was making sure. And those 3 charges have the offense date of May 21st, 2022. What do you have pre-trial?
6 total. He was arrested last Friday for DUI, 2 counts. He went to the city jail for that.
Okay.
Before that was 2017, possession of cocaine, meth, and marijuana. Those were dismissed. What else? 2015 failure to appear DUI. He was later convicted in 2015 for DUI. I got a sale of marijuana, possession of a knife or a firearm during the commission from 2011. That was dismissed. That's it.
All right. Ms. Brown?
Yes, Judge. On May 21st of 2022, the officers responded to the intersection of Far Road and Piedmont Road, spoke with the victim, Mr. Ohanian. He indicated he was driving a Volkswagen Passat when the defendant attempted to turn into Waffle House and then immediately get back into traffic without yielding and struck Mr. Ohanian's car. Initially got out, but when was asked for his information, left the scene and did not return to the scene. The officers based on the information that was given to the officers by Mr. Ohanian, they issued a warrant, and he was later picked up on the warrant. And at the time he was picked up on a warrant, he was arrested for DUI. Our recommendation for bond in this case is a $2,500 signature bond. No driving without a valid driver's license, no alcohol, drugs, or weapons. And that would be 1,000 on the hit and run, 1,000 on the no insurance, 500 on the failure to yield.
All right.
Is it a signature bond through jail, Your Honor? That she's recommending, Ms. Brown?
What was your recommendation, Ms. Brown? Did it matter?
It doesn't, Judge.
Okay.
So we would like to request for a signature bond from through the jail, Your Honor.
All right. All right. I will go ahead and enter the $2,500 signature bond through the jail. There will be 1,000 on the first charge, failure to yield, 1,000 on the hit and run, and 500 on the driver leaving the scene. There will be no drugs, alcohol, or weapons while on bond. Only driving if you have a valid driver's license, Mr. Martinez. If you do not, then you should not drive. And I think that is going to be it.
Thank you, Your Honor.
Okay.
What the bond amount again? I'm sorry.
2,500 signature bond through the jail.
Okay. Next, we will bet number 17, Mr. Smith.
I think I saw the attorney there on the screen.
I'm here, Judge.
Okay, good.
Hey, Judge, I wasn't exactly prepared for this. I've had some personal matters to deal with today, so I'm sorry for my casualness. I'm usually not in my car, and I usually have a suit on.
Well, I'm glad you could, because his case was reset. So thank you for getting on.
Sure.
I do understand. This is case number 22 CR 003807Y, State versus Antonio Lee Smith, charged with 1 count of battery family violence. And I believe with pretrial, we went through, or do you have that?
I got it.
Okay.
I got 17 total.
Okay.
Last arrest was in February for battery. That's open 22 MAGC 00983. Has an open ag assault strangulation 22 CP 207016. On federal probation out of Kentucky. Convicted felon in possession of a firearm. He should be done with that December 3rd, 2023. He had the August arrest for ag battery, simple battery family violence out of Clayton County. Before that was a 03 non-pros. That's the Georgia history. He got old Georgia history, like from the 90s.
All right.
Yes, Your Honor. As with what pretrial stated, in addition that there's an open ag assault strangulation that pretrial mentioned. It's against the same victim. That's that 22 CP 207016. He's currently out for that case on a $30,000 surety bond. And there's a no further contact with this victim provision in that bond order. In addition, that ag battery and battery family violence out of Clayton, like I said before, it's open and pending in front of Judge Malone for Clayton County. That case carried a $35,000 good bond with no further contact with that victim, who is different, but it also includes a provision of no other violations. And that bond order was taken out by that judge in 2020. So it preceded these charges that we're here on today. As pretrial initially also stated, he has convictions out of the 90s for drug-related offenses and entering auto. The victim in this case, Your Honor, is Deshaun Watkins. Deshaun is spelled D-A-S-H-U-N. Watkins, common spelling. The incident took place on May 31st, 2022 at 900 Sells Avenue. Sells is S-E-L-L-S. In this incident, the victim in this case, Ms. Watkins, called the police and reported that her boyfriend, the defendant in this case, attacked her. She stated to officers that the reason that she was attacked is because that he was upset for being arrested on the previous offense against her, which is that open ag assault that I mentioned earlier. She mentioned that they had got into an argument about that and that he punched her several times in the face, which resulted in visible bloody mouth and a swollen bottom lip. Officers reported that that injury was immediately apparent upon arriving on the scene. And when asked Ms. Watkins what happened, she relayed the same information to the officers. Your Honor, we have a serious concern in this case due to the risk of reoffense in this case. Even though our victim said that she is not afraid of this defendant, we are concerned about the cycles of violence in this case and the risk of reoffense, being that there is an open ag assault case with this victim involved, as well as the fact that there's an additional felony ag assault case open against a different victim. So we're concerned about the risk of reoffense as well as the intimidation of this particular witness, because as the facts allege, she got beat up for getting him arrested last time. Given that and the fact that he has these open charges, one of which is against the same victim and is currently violating a no contact order, the state is going to request a $7,500 cash only bond, no further contact with the victim in this case, a stay away from the incident location, 1-day anger awareness, and no alcohol, drugs, and weapons.
All right. Mr. Melnick?
Thank you, Judge. So I have actually met with the victim in this case. She came to my office and she has told me unequivocally that she will get mad at Mr. Smith. She will fabricate these allegations. She will call the police and that he did not do any of the things that she reported to the police. I realize that that is often a cycle in these types of cases, but I can only accept her at her word as to what she told me. Beyond that, Mr. Smith was gainfully employed at the time of his arrest. He has strong ties to the community. And I would ask that he be given a bond that he can reasonably expect to be able to make. I don't have any problem with any of the special conditions that the state asked for. What I would ask you to do is grant him a $15,000 cash surety or property bond, and that he comply with the other terms and conditions that the state had requested, including the no contact order and the class that the state had requested. I don't think any of that's unreasonable, but I think that $7,500 cash only, which is the equivalent of at least a $50,000 bond, if not more than that, is more than should be expected from somebody with misdemeanor charges who is entitled to bond as a matter of law. So that's what we are asking for, Judge, $15,000 cash surety or property with the other conditions the state has asked for.
Your Honor, if I may.
Okay.
The state finds the issue with the categorization that this victim would fabricate the allegations alleged in this case. Furthermore, officers stated that her injuries of a bloody mouth and swollen lip were apparent to them immediately upon arriving on the scene. And we just want to reiterate that this defendant is currently under a no contact order with this particular victim in an aggravated assault strangulation case that is open in Fulton County, as well as other open extremely violent offenses, and currently had a total of $65,000 in surety bonds already, and has chosen to violate the conditions related to those. So we would ask if it's in your Honor's purview to grant the $7,500 cash bond, given the facts and circumstances related to that.
I mean, I can only go by what the victim told me. I have actually spoken with the victim herself. She came to my office and met with me on her own accord. I didn't contact her. She contacted me.
Yeah, I wish you could have encouraged her to get on the Zoom link today. I do like to hear from my victims directly rather than, hearsay.
All right. Well, I mean, in all honesty, Judge, it's hearsay both ways, candidly. I mean, as an officer of the court, I'm telling you that I've met with the victim.
Okay.
And she did indicate that she would be on the Zoom yesterday. However, Your Honor, we don't see her today. And she also is the one that reportedly called the police in this case. Nothing further from the state.
All right. What kind of work did you tell me Mr. Smith did or does, Mr. Miller?
He works in construction, Judge.
He's 49 years old.
That's correct.
Does he reside at the Sills Avenue?
Mr. Smith, is that where you're going to be living?
That's fabricated. That is not my address, Your Honor. I do not live on 900 Sales. I live 401 Palmanac Circle, Atlanta, Georgia, 30315. It was fabricated. They Sean Watkins have seizures. My dad supposed been in the court for me. She do this to me all the time, Your Honor. I'm tired of it. I'm an old man. She get mad by other women and all that. I do not do that.
Okay, Mr. Smith, that's okay. All right.
Yes, sir. Yes, sir.
Well, he does not reside there. Okay.
That's correct.
Ma'am. It's 401 Palmanac Circle, Atlanta, Georgia, 30315. That's where I reside.
What I'm going to do is the $15,000 surety bond. Going to order that. I'm going to order that you stay away from 900 Sales Avenue. I'm going to order that you have no further contact with the victim, Deshaun Watkins. You see her coming, you need to go the other way.
Yes, ma'am.
You aren't rearrested. I'm going to order the one-day anger awareness course. And I'm going to also order no drugs, alcohol, or weapons while you're on bond. All right, anything else I need to take up, counsel?
Not from the defense, Judge.
Nothing further from the state, Your Honor.
Okay, thank you, Mr. Miller. I appreciate it. All right.
Thank you.
Thank you, Your Honor.
Number 13, Mr. Mack.
Case number 22 CR 003822J. Rodney Mack, you're charged with 1 count of theft by taking. The offense date is February the 4th, 2022. Retrial.
29 total. Last arrest was last Thursday. Possession of drug-related objects. He went to the city jail for that. I got convictions for misdemeanor possession of marijuana, possession of drug-related objects from 2019. He had a 2018 arrest for entering auto. Cocaine dismissed. 2016 parole violation. 2015 theft by taking, entering auto. The entering auto was a conviction. The theft by taking merged with that. Got 2011 parole violation. 2009 entering auto, simple battery conviction. Another 2009 entering auto conviction. 2007, same thing. 2006, same thing. I'll leave it at that. That's it.
Okay. All right, Ms. Brown.
Yes, Judge. An officer responded in this case to 781 Myrtle Street and spoke with Mr. Wade Mark, who indicated that a package that had been delivered to his home for his husband, Jeffrey Swart, had been stolen. They were able to identify Mr. Mack by video footage from the victim's home. They identified an individual, issued a BOLO, and officers were later able to identify him based upon officer recognizing him from the video. And it appears from Mr. Swart that items stolen was less than $100. Our recommendation in this case, he already has a surety bond in the amount of $1,500, Judge. We're just asking that bond remain in place. As you heard from pretrial, he has quite a few convictions. Almost all of them are theft-related crimes, about 4 prior theft charges, another 5 entering autos with the intent to, to steal something. So he's definitely a risk to reoffend in this case, and most certainly another theft charge, Judge. And so we would ask that the 1,500 surety bond remain in place. A stay away from 781 Myrtle Street, Atlanta. No alcohol, drugs, or weapons.
All right. Ms. Kim?
Yes, Your Honor. Mr. Mack is 62 years old, Your Honor, and this happened on February 4, almost 4 months ago. And he does have a job right now, 2 jobs, as a restaurant cook and assistant chef. And he really, really want to keep those jobs. And he graduated from high school. He also has a junior level of college education. We would like to request for signature on bond. Pretrial services actually recommended for unsecured judicial relief for this case.
That was a typo.
We will take the typo too. We will get the signature on bond, Your Honor. So please give him a signature on bond so he can keep his job. And he served for Navy from 1980 to 1988 for USA, United States of America, our country. So he needs some time off. And keep a job, please. Thank you.
All right, I'm going to keep the $1,500 surety bond in place. Stay away from 781 Myrtle Street. No drugs, alcohol, or weapons while on bond. And I think that is all that I need to take up. Is that correct?
I believe so, Judge.
All right.
All right, next we got number 24, Mr. Nunez.
'22 CR 003823F. Mr. Yunez, you're charged with 1 count of criminal trespass. Offense date June 14, 2022. Through trial.
This is 10th arrest. Last was February, criminal trespass. January, theft of services. 2020 burglary, 2nd degree. He was given probation for that in 2021. They only gave him a year, so he should be off of probation for that. 2019 shoplifting. 2019 failed to appear out of Milton. 2019 trespass. 2019 another trespass. 2019 shoplifting conviction. That's all.
All right, Ms. Duncan.
Yes, Your Honor, this incident occurred at the Inman Quarter Apartments located at 299 North Highland Avenue in Atlanta, Georgia. This defendant, well, I'm sorry, let me start over. The police were contacted by Mr. Rogers, who represents the Inman Quarter Apartments, in reference to someone who keeps coming to the property in places like the leasing area, lobby, the swimming pool area, the trash cans, also that are located in the parking deck, and indicated to officers that he would often remain on the property and sleep there overnight after being told that he could not be on the property and given criminal trespass warnings. The defendant in this case was identified after being seen on surveillance after continuing these trespasses. We have a concern about the risk of reoffense in this case, Your Honor, given that this defendant does have a lengthy history related to criminal trespasses, and as the facts allege, several trespasses at this location prior to this arrest, as well as the conviction in 2019. We do have a flight risk concern because there is an FTA on the record from 2019. Given those facts and circumstances, we're going to request a $2,000 surety bond, a stay away from the incident location, and no alcohol, drugs, and weapons.
All right. Ms. Kim?
Yes, I want to clarify if the pretrial recommendation for signature on bond for Mr. Hughes was also typo or not, because he was recommended but anyway, Your Honor, he is 24 years old and he has had some challenges in terms of residential housing issues. However, he is finally able to connect with his mother, and he will be joining into his mother's place in Alpharetta. He has been here in Georgia all his life, 24 years. He does not have a children, and yet he will be. He has a strong ties to the community. He graduated from high school here in Georgia. He does not have a job yet, and yet hopefully that his moving situation with his mother will make changes. We would like to request for a signature on bond, Your Honor. Thank you.
All right.
If I may, Your Honor, these 10 arrests started in 2019, so not that long ago. And this defendant has racked up numerous amounts of criminal trespass arrests and convictions since then. So we will request in this incident, as well as FTA, so we will request that surety bond recommendation be granted by the court.
All right. I'm going to order the $2,000 surety bond. I'm going to order a stay away from 299 North Highland Avenue in Atlanta. Mr. Eunice, please do not go back there, else you'll just end up right back here, arrested again. Stay away from that complex. I did not get the name, but no drugs, alcohol, or weapons while on bond. And I am imploring you to stay away from 299 North Highland Avenue to that apartment complex.
For the record, Your Honor, if I may, the apartment complex is named the Inman Quarter Apartments.
Okay, the Inman Quarter Apartments, okay?
Yes.
All right, so Mr. Eunice, please stay away. And no drugs, alcohol, or weapons while on bond, so $2,000 surety bond.
Thank you, Your Honor.
Thank you, Your Honor.
20, Mr. Tucker.
22 CR 003830Y. Jeremiah Tucker, you're charged with 1 count of disorderly conduct, 2nd count of simple battery, family violence, both with the offense date of June 14, 2022. Pre-trial.
His second arrest. He was arrested in February, battery DV, ag assault, family violence. I think it was 2 counts. That's open, 22 SC 182204. That's it.
All right, Ms. Duncan.
Okay, one moment. My computer stuck. Okay. This incident occurred yesterday at 115 Hillage Street Northeast. In this case, officers were called to the location by a witness that stated that the defendant in this case was abusing the victim in this case. And she stated that she observed the defendant chasing the victim in this case on foot down the street and grabbing her backpack and began to drag her down the street. And the warrant indicates that she actually hit the ground in this encounter. She said the police report indicates that the two were yelling at each other. When officers spoke to the defendant and the victim, they denied that anything had happened. However, given the witness statements about what had occurred when officers arrived on the scene, they saw the aftermath and they took the defendant into custody believing that at the time he was likely the primary aggressor. While handcuffed in the back of the squad car, this defendant overheard the officer talking to the victim in this case about the allegations, and he spontaneously erupted and stated to officers that he did in fact grab the victim's book bag in this case. Your Honor, we have a concern about the risk of reoffending in this case, given that this defendant does have an open felony ag assault and family violence, 2 counts, as well as battery family violence against the same victim, and is currently out on a $20,000 good bond with a no contact order that was given by Judge Wolf in February of 2022. Given those facts and circumstances, Your Honor, the state is going to be requesting a $5,000 cash only bond, no further contact with the victim in this case. If there's children involved, third party contact, stay away from wherever the victim resides, since this incident occurred while they were in the middle of the street. I don't have the address for the victim in this case. And if there are any personal belongings at the victim's residence, we'd ask that the defendant have a one-time police escort, no alcohol, drugs, and weapons. I am aware that I did not state the victim's first name in this case. I'm having a computer glitch. If Ms. Kim would state the victim's name in this case for the record, I would appreciate it.
Yes, for the record, it is Laprincia, Laprincia Harris. From my understanding, Your Honor, they are both homeless at this point, residentially challenged. I'm actually recommending for behavioral health evaluation for my clients, and he is 22 years old, and he does not live together with Miss Harris. They have no children, and their relationship is a friendship, and yet there's no, it is okay to stay away or no further contact with each other. However, due to the fact that he has been unemployed and residentially challenged, he's not going to be able to make any further bond payment. So we would like to request for signature on bond. And yet, because of the open case, which he is presumed to be innocent, if Your Honor is not inclined to give him a signature on bond, we request for maximum $1,000 surety bond, Your Honor. Thank you.
All right.
Your Honor, if I may, at the time of the incident, it was indicated that these two were in a relationship.
Okay. And so with the address, are we sure who resides at the North Highland Avenue?
I don't think that that's one of their addresses. I think that's just where they got stopped. The facts indicate that they were walking towards a train station.
Oh, okay.
My client will have a mailing address from First Presbyterian Church, so we will be able to contact and send the notice to him.
Okay, this was the one, I think I said the wrong address. This is the 115 Hilliard Street.
Yes, they were walking towards the King Memorial train station.
Okay.
They were walking southbound, and that's just where they got stopped.
Okay. And is there, again, did you tell me there is or isn't a present bond?
Currently on the open case, there is a bond in the amount of, in the open ag assault case from Judge Wolf, there is a $20,000 good bond with a no contact provision against this particular victim from February 2022. There is no current bond set for this charge. That's why we're requesting the $5,000 cash bond, because this defendant is in violation of that no contact order and the violent nature of this offense and the other facts and circumstances alleged in accordance with the IALA factors.
All right. All right, I'm going to order the $5,000 cash bond. I'm going to order A stay away, well, not a stay away, but no further contact with the victim, LaPrincia Harris. No drugs, alcohol, or weapons while on bond. And I don't know, is there anything else I need to take up?
Break down that bond, Judge.
Oh,
Okay.
I'm sorry, with the 5,000 cash, 2,500 on each.
Okay.
And is there anything else, counsel, that I need to take up?
Since we don't have an address to stay away, then no further contact should be sufficient, Your Honor. I'm unsure if they have children. Ms. Kim, are you
I
aware?
think Ms. Kim said no children.
Okay, so
Your Honor.
nothing further, Your Honor.
All right, nothing further. Thank you.
Number 7, Mr. Faust.
Okay. This is 22 CR 003828A. Mr. Is it Faust or Faust?
Faust.
Faust. The charge at 1 count of simple battery family violence. That offense date is January the 20th, 2022.
7 total. Last arrest was November 2021. Simple assault, felony theft by receiving, cruelty in the first. That was out of Thomaston. Not sure about whether or not it's still open. May 2021, Clayton County, battery, criminal trespass. June 2020, Griffin, reckless conduct, robbery. The robbery was amended to theft by taking. What else we got here? 2019, Huron County, battery, simple battery, family violence. Battery against a female who is pregnant. Simple battery against a person who is 65 years or older or who is pregnant. He got PTI, so they were later dismissed. 2019, shoplifting out of Lithonia. 2019, criminal trespass, dismissed out of Gwinnett. He wasn't recommended. That's it.
Okay.
Yeah.
All right, Ms. Harmon.
Yes, Your Honor. The location of the incident is 1220 Gun Club Road in Atlanta. Your Honor, my understanding is that the parties do share a child. The brief facts are is that the defendant chased the victims, whose name is Bria Williams, and I'll spell Bria for the record, BRIYAH Williams, chased Ms. Williams' vehicle from the address of 2315 Donald Lee Hollow Parkway to the incident location at 1220 Gun Club Road, where the incident took place. The victim stated to police that when she stopped her car, the defendant approached her vehicle and pulled her by the hair in an attempt to take her out of the vehicle. She told police that the defendant was upset because she told him that she no longer wanted to be in a relationship with him. Our office did reach out to the victim in this case, who I do believe is online here at the Zoom conference. She said they do not live together, they're in a relationship, and I stand corrected, Your Honor, they share 3 children. The victim stated that she does not want to press charges and that she was just angry that day. She did confirm, however, that the defendant did in fact pull her hair, but she made the distinction to say that he didn't yank it. And then I'll let her testify to anything else. And she did say this was the first time anything that like this happened. The fact that he followed her and attacked her is concerning. And even the victim said that he did pull her hair, yanking, pulling, it's all the same. He followed her, and when she stopped, he went up to her car and yanked her by the hair. It's so I do think he is a danger to this victim. Furthermore, Your Honor, it's concerning that he does have some arrests on his GCIC that involve family violence and violence. Mr. Howard told you about the battery family violence out of Henry County that went to diversion in the Clayton County battery that is very recent in March of 2021, and the arrest out of Thomaston, Georgia in November of 2021 for simple assault. So we do think that he posed a risk to reoffend. So our recommendation in light of the foregoing is a $3,000 surety bond, no further contact with the victim, a one-day anger awareness, no alcohol, drugs, or weapons, a third-party transfer of any children, and to stay away from the incident location. Nothing further.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Corey Faust is 23 years old. He has been in the Atlanta, Georgia area his entire life. Yes, he shares 3 children with the complaining witness, Ms. Bria Williams. Ages are 4, 3, and 1. Your Honor, he also has 6 other minor children, ages 7, 4, 2, and 3. Your Honor, we are opposed to any stay away and no contact orders. I did have the occasion to speak to Ms. Williams. She states that she wants to continue having contact as these parties have resumed relations since the alleged incident. Your Honor, Mr. Faust completed high school. He was enrolled in college on a football scholarship. However, he had to stop attending for reasons. Your Honor, he is employed at Sam's Resource. He has been in that position for about 1 month. Prior to that, he was employed at First Choice Building Doors for only about 4 or 5 months. So we do have some concerns regarding the continuity of employment and also the number of children that he has in terms of his ability to pay bond, Your Honor. He denies the allegations. And while I do acknowledge my client's history, what I heard is that he does not have any convictions for violence, Your Honor, and Your Honor should not rely on arrests that have not led to convictions. I am requesting a signature bond on Mr. Faust's behalf, and if Your Honor determines that he is ineligible, I would ask for the simple battery charge of no more than $1,000. Again, we are opposed to any no contact and stay away orders. Thank you, Your Honor.
All right.
And Your Honor, if I did not say that, my client strongly denies these allegations. He says there was no argument whatsoever, and he denies making any contact with her.
Okay. All right, I'm going to order a $3,000 surety bond.
Your Honor. Ms. Faust.
Oh, I'm sorry.
Sorry, Ms.
Sorry, yeah. I just see numbers. So is it 970 something? Is that Ms. Williams?
Yes.
Okay. Would you like to address the court today, Ms. Williams?
Yes, I don't want to go.
Hold on a second. I swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And what would you like to tell me again?
I don't want to go through with the charges. Like I said, when it happened, I was mad at the time. And yeah, we still had relations right after and when he got locked up. So yeah.
Okay. All right. And you have 3 children together?
Yes.
Okay. 4, 3, and 1?
4, 3, and 2.
4, 3, and
no,
2.
5. I'm sorry. 5, 4, and 2. I'm sorry.
Gotcha. All right. And you're not married, correct?
No, we're not.
Okay. All right, I'm going to still order the $3,000 surety bond. Ms. Williams, I thank you for your time appearing today. $3,000 surety bond. I'm going to order that there be no further violent contact between the 2 of you.
Okay.
And so who lives, or do either of you live at this 1220 Gun Club Road?
Yes, me and my kids.
Okay, so I'm going to order that Mr. Faust right now stay away from the Gun Club Road.
Okay.
And he will get a one-time police escort back to that location to retrieve any personal items that he may have there. But while on bond, I want to make sure that there will be no more incidents with the 2 of you. So I'm going to order him to stay away right now.
Okay.
No drugs, alcohol, or weapons while on bond. And I was going to say there's going to be visitation since he has to stay away from that location. But I had no further violent contact with you. So do you think you'll be able to safely exchange the children if he's going to get visitation?
Yes, I do. I don't feel no harm or anything with them.
Well, you may not feel it, but I want to make sure that Mr. Faust knows if you're going to visit with your children, you're to have no further violent contact with the mother of the children, with Miss Williams. Do you understand that, Mr. Faust?
Yes, ma'am.
Okay, I would say that you need a third party person to transfer, but if Miss Williams says you all can do that without any violence, then let's try it and see what happens.
Oh, he can meet like at a park or something with
Yes,
them?
public place, that would be fine.
Okay.
Yes. All right.
Okay, okay.
Let's do that and hope that we can get past it. I'm also going to order Mr. Faust to take a one-day anger course. All right?
Okay. Okay.
Your Honor.
That's for you.
Your Honor.
Yes.
With all due respect, I just want to make sure that I'm clear on the orders. So they are to have no violent contact, but he is to stay away from her residence. And if they are in contact, it's solely for the purpose of transferring the children.
Correct.
Okay, and Your Honor, I would ask, since he does have the surety bond and that he's not going through pretrial services, that Your Honor waive the one-day anger awareness solely because, his financial obligations, his limited employment, and I just don't want to set him up to violate a bond condition, Your Honor, with that one-day anger awareness class.
I'm a little concerned about it. It says that he's working. Are you telling me that he was working?
Just for 1 month, and prior to that, he worked for 4 or 5 months.
Your Honor, and we would ask that you would keep that condition in place. I think this is necessary in light of the facts alleged in this incident and the arrest history. I think this is necessary for him to learn some techniques so that this does not happen again. And we're not in the same situation, given the fact that you are not going to require them to stay apart. He does need some tools and techniques so that he can cope with any other situations so they don't blow up to this level again. So I would ask that you would keep that in place.
And with all due respect, Your Honor, I certainly appreciate the state's input. However, my client has not been convicted of violence. He is presumed innocent.
I understand, but I want him to learn some tools. They have three small children. That may add to some of the stressful issues at this time. So I'm going to keep the one-day anger awareness course in place so that we can, as the state says, I tend to agree, make sure since they are going to have some contact, and that's mainly because the victim states that she still wanted some contact with them. So you should take that one-day anger awareness course. Ms. Williams, I may need you to mute yourself.
I'm sorry.
Okay. So.
And lastly, Your Honor, I do apologize for interrupting. Mr. Faust informs me that he does not have any belongings at her home, so we will not need a one-time law enforcement escort.
Okay. All right, Ms. Bridgewater, can amend that.
Okay.
All right, is there anything else I need to take up?
Yes, ma'am. I was trying to.
Mr. Faust, the judge has ruled I will give you a call at the courthouse to address your concerns.
Okay.
All right, thank you, Your Honor.
All right, thank you.
Thank you.
Number 4, Mr. Cyrus.
That's my case, Judge.
Okay. All right, this is 22 CR 003826A. Mitchell Cyrus, charged with 1 count of battery, offense date June 14, 2022, pretrial.
7 total. Last arrest was in March, criminal damage to property, 2nd degree. That's 22 SC 207831.
All right.
Hold on. 2017 false report of a crime arrest. Got a 2013 reckless conduct. It just says bond over. Why they print this out like this? I got history out of New York, criminal mischief, intent to damage property. That was from 2007. That's it. Everything else is old.
Okay. What was the total number again?
7.
7. Okay. All right, Ms. Harmon.
Yes, Your Honor. The incident location in this case is 7909 Roswell Road in Sandy Springs. The victim, her name is Victoria Jackson. On the offense date, the officers responded to the incident location where officers observed Ms. Jackson bleeding in the driver's seat of her car. The defendant advised officers that Ms. Jackson showed up to his house uninvited. The parties got into an argument because he alleges that she broke his cell phone. Ms. Jackson got in the car to leave, and the defendant, admitted that he threw the phone into the car, not knowing that it hit her in the face. Ms. Jackson said to officers that he took her phone while she was sitting in the car, and he was inquiring about who she was on the phone with, and then he threw the phone at her, hitting her in the nose. Your Honor, we believe that this defendant presents a risk to reoffend because in that criminal damage to property case that Mr. Howard just cited to, there was an order for the defendant to stay away from Victoria Jackson. That was issued on 3/28/22. So it's clear that he doesn't follow court orders. And in that case, he was given a $2,000 surety bond. And I understand in my recitation of the facts, I stated that Ms. Jackson showed up to his house uninvited because that's what the warrant states. However, the defendant is well aware that he is not to be around Ms. Jackson, and he could have simply gone back into his home. He could have chosen not to engage with her. Instead, they got into this argument where she ends up bloody in the front seat of her car. And that's why we would also say that he's a danger to the victim. Based on the incident detail and the criminal damage case, we went from a property crime to now we're at a crime against her person. So I feel like the violence is escalating with this defendant against this particular victim. Our recommendation based on the foregoing is a $4,500 surety bond, no further contact with the victim, a one-day anger awareness course, and no alcohol, drugs, or weapons. And I believe the incident location is the defendant's home. So we wouldn't ask, and I don't believe they live together. So we wouldn't ask that he would have to stay away from his home. Nothing further.
All right. Mr. Murphy.
Judge, my client has lived in Atlanta for 11 years. He's a chef at Cheesecake Factory. He went to a culinary school and has been at that employment for the last 4 years. He's a single parent. He's got a 14-year-old son that resides with him. Fortunately, there are friends and family that are managing the apartment with the 14-year-old while my client sits in jail. But the protective order basically goes both ways. And here we have Victoria Jackson showing up at my client's apartment unannounced. And my client contends that he was ill, under the weather, and opened the door inadvertently. Had he looked at the peephole, he would have not opened the door, and that she essentially barged in. She showed up at his residence. He didn't go out to where she was, and that he contacted the Sandy Springs Police Department, and then they made a determination based on a disagreement to arrest my client. Now, my client is vested in the community, has a stable job, has a 14-year-old he's in charge of, and we have this Miss Jackson's relationship. As a former fiance, but she came over unannounced to the complete surprise to him. He had no idea that she was turning up, and then had some sort of grievance. But I'd like the court to consider a signature bond in this matter, given the circumstance of who went where. She shows up at his apartment, not the other way around. He certainly didn't put anybody under any surveillance or any harassment. Again, that's the facts as we see them. I'd ask the court to consider a signature bond to let him get back out, maintain his employment, and be back taking care of his 14-year-old son. Thank you, Your Honor.
All right, thank you. All right, I'm going to order the $4,500 surety bond. I'm going to order that there be no further contact with the victim, Victoria Jackson. Gonna order, is that gonna be a stay away from 7909 Roswell Road, or make sure among these addresses?
Judge, that's his apartment, not hers.
Okay, all right, so if he's having no further contact with the victim, do we want to put an address in or just leave it with that?
We'll leave it with that, Your Honor.
Right, I don't have a,
All right. No drugs, alcohol, or weapons while on bond. And the one-day anger awareness course.
That's a $4,500 good bond, Your Honor.
Yes. All right, that should conclude this case.
Thank you, Your Honor. Mr. Cyrus, I'll reach out to your family right now. That's all I have, Your Honor. Thank you.
Okay, thank you. You may be excused if you'd like, unless you want to stay to reconcile.
Yes, we got number 18, Mr. Stinson.
Okay.
Your Honor, if I may, before we begin, I just put a message in the chat.
Oh, let's see. Oh. Hold on,
Who are we on?
18.
18. All right, this is case number 22 CR 003817Y. Jason Stinson, you're charged with 1 count of simple battery. The offense date is January the 5th, 2022. Pre-trial?
This is 5th adult arrest. Last arrest was February 2020 for shoplifting. 2014 shoplifting conviction. 2012 suspended license. As far as violence, he got an 01 kidnapping robbery conviction out of DeKalb County. He got 4 holds. DeKalb, Gwinnett, Coweta, and Putnam.
All right.
The Putnam is a fraud case. Coweta is a fraud case. I don't know what the other 2 are, but that's it.
Okay. All right, Ms. Duncan.
Your Honor, in addition to that, I have a failure to appear warrant out of, let me see.
DeKalb, it's out of DeKalb.
Out of DeKalb, and then the other 2 that I have are fraud.
Okay.
Okay. This incident occurred, as you stated, on January 5th, 2022 at 2891 Springdale Road. The victim in this case is Garcia Coney. That's Garcia, last name Coney, Coney. Your Honor, in this case, I'm going to start out with saying that the state is going to be requesting a $5,000 surety bond, no further contact with the victim in this case, and stay away from the incident location, and no one-day anger awareness, and no alcohol, drugs, and weapons. Your Honor, this is largely in part due to the facts and allegations alleged in this case. Your Honor, in this case, the facts allege that there was a altercation between the defendant and Ms. Coney, and during this altercation, the defendant in this case whipped Ms. Coney like she was a child. He hit her with a belt about 12 times. He struck her in the face with a closed hand about 6 times. He slapped her in the face about 3 times. He tried to choke her using one hand, like he was trying to lift her off the ground, when he was grasping her. In further communications, Your Honor, we have indications that in this case, specifically, after that choking, this victim, my apologies, did have trouble concentrating. She stated that while she was being choked, her ears were popping and she was having trouble concentrating after being choked by this defendant. She stated that while she was being choked, she was also being punched and slapped in the face. And she is concerned for her own safety. She would like no further contact with this defendant. Your Honor, given those facts alleged and the egregious nature of the violence in this case, we request a bond as stated, and we would request the conditions as mentioned, given the nature of this case and the risk of intimidation to this witness and possible risk of reoffending if they're allowed to be in contact.
Okay.
Yes, Your Honor. I believe there's a Miss Garcia Coney, and yet I would like to go first. My client claims that he is also a victim of identity theft. It is his cousin, who is 2 years older than him, is doing all this and yet giving his name. The relationship between Mr. Stinson, Jason, Antoine, his mother's brother's son, his name is, that's basically him. And my client is Demontra Stinson. No. The person who actually committed the offense is Demontra Stinson, and my client is Jason Antoine Stinson, whose birthday is November 1st, 1981. The very person who committed this crime is another Stinson, whose birthday is July 14, 1979. They are cousins, they look alike, their age is similar, and yet they're completely different people. And Mr. Jason Antoine is 40 years old, and he has been here in Georgia for all his life. He has no children. He's not married. He's not the one who's in a relationship with Garcia Coney, and he has no job for about last 2 years. His education has been 7th grade. That's the highest level of education he has had. We actually would like to request for signature on bond so that way he can get out and also resolve 4 other charges. 3 of them are not his at all. So he has to actually clarify with his cousin.
Okay.
That's it, Your Honor. Thank you.
If I may, Your Honor, be given one second to verify something. In this case, Your Honor, the victim alleged that the defendant's actual name is Demontre Stinson. However, he does from time to time use his cousin Jason's name, and both names are listed on the GCIC as aliases. I just want to check one thing, 1 second.
I got the message text that says Garcia Coney to everyone. I scrolled and this is not Demontra Stinson that he is accusing of. So my client who's sitting right there at the courtroom too is a different person, Your Honor.
Yes, I see that. I see the picture of, I see what we have, Your Honor, and I'm trying to verify the situation that we currently have. This is news to me. I did know that she stated that she sometimes uses another name.
Yeah.
Just trying to make sure that this is the right person.
I know one of those warrants does have the Monterey Stinson on it.
Yes, the incidents alleged in the case that I recited does have the Monterey, but in doing
No,
it,
I was talking about that one of that foreign hold warrants.
yeah.
Yeah.
Putnam, the one from Putnam. However, the other ones, no.
One moment. I'm just double checking. My apologies, Your Honor. I beg the
No, it's
court's
okay.
indulgence.
We need to be sure, as clear as we can.
Mr. Stinson, I would like to recommend you to stay silent. Let me do my job and help you.
Okay, according to Your Honor, apparently that is not the person who attacked our victim in this case.
Yeah, I see that.
They use names interchangeably, but apparently this is not the person.
This is not him. Okay.
Correct, Your Honor. Signature bond, please, Your Honor.
All right, I will give a $5,000 signature bond. I asked through the jail.
Thank you, Your Honor.
And we'll go from there. I guess, Ms. Kim, you'll know what to do from here, right?
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
All right.
Yes, we got number 6, Mr. Evans.
Say that position again, Deputy.
Number 6, Mr. Evans.
This is 22 CR 00383-4C. Joseph Evans. You're charged with 1 count of theft by taking. Actually, 1, 2, 3, 4 counts of theft by taking. Offense day, May 16th, June 7th, June 2nd, and June 9th. Pretrial.
17 total. Last arrest was May 6th, shoplifting. February shoplifting. Hold on. Another February shoplifting. June 2021 shoplifting, giving false name. May 2021 shoplifting. Trespass conviction 2018. 2013 probation violation. 2013 shoplifting. 2010 escape conviction. Escape from work release. Another 2010 probation and 2019 probation violation. He got an FTA warrant out of the city of Atlanta too. That's it.
Okay. All right, Ms. Harmon.
Yes, Your Honor. As you know, there are multiple offense dates here. In count 1, the defendant is alleged to have taken a power jack valued at $500 from the loading dock of a Dollar Tree located at 3599 MLK Drive. That theft was recorded on surveillance on the date of 6/2/22 at the same location. The defendant is alleged to have taken household items and clothes valued at $148.65. That too was recorded on surveillance, and he passed all payment points without paying. In count 3, it's the same location. The defendant is alleged to have taken household items and clothes. And I didn't note the value of that, Your Honor, but it's under $500, and that was on June 7th, 2022, recorded on surveillance, passing all payment points. And then the last count, count 4, taken, defendant is alleged to take household items from the same Dollar Tree. The value is under $500 on June 9th, 2022. That too was on surveillance, and he passed all payment points. I think, Your Honor, from the fact that what is alleged here, 1 count of theft by taking and 3 shopliftings, that he clearly has a risk of reoffense. If you couple that with the 5 arrests for theft by shoplifting since May of 2021, and I acknowledge that those are just arrests, but that is very telling in itself. in light of that, Your Honor, and the FTA, and I didn't note that in my workup of the case. I don't know how recent that is, but of course, that should be considered towards the IALA factors as well. We would recommend on each count a $500 surety bond for a total of a $2,000 surety bond to absolutely stay away from the incident location, which is the Dollar Tree, no alcohol, drugs, or weapons, nothing further.
Okay. All right, Ms. Gant.
Thank you, Your Honor. Mr. Joseph Evans is 32 years old. He has been in the Atlanta, Georgia area for 8 years. Your Honor, he is the proud father of a 9-year-old. He informs me that he does not have any family here to help him with bond. In fact, his grandmother died recently. We are unopposed to the stay away at the incident location. Mr. Evans completed high school. He also went on to study in college 2 years, and he studied in the areas of engineering and mobile technology. Your Honor, he is unemployed at this time and has been so for a while. He does not have the means to pay anything toward bond. He also is dealing with housing issues. We are connecting him to social worker services so that we can help with his living situation. Your Honor, I'm requesting, despite my client's history, a signature bond as he does not have the means to pay bond. We heard a lot about arrests. We did not hear about too many convictions, and he is presumed innocent in any open case, including this case as well. If Your Honor determines that he is ineligible for a signature bond, then I would ask for a bond of no more than $250 for each offense, and that would be a total of $1,000. Thank you, Your Honor.
Okay. All right, I'm going to order the $2,000 surety bond, $500 on each charge. I'm going to order a stay away from the Dollar Tree at 3599 Martin Luther King Drive. Mr. Evans, please don't go back there unless you just want to be in jail forever. Just don't go back to the Dollar Tree. Please stay away. I don't know how I can impress upon you to do that with the allegations here. No drugs, alcohol, or weapons while on bond. And that will be all that I'll order at this time. Anything else, counsel?
Nothing further. Thank you, Your Honor.
Nothing further.
Thank you.
Yeah, that should do it for us in courtroom 2.
All right, thank you. Have a good one.
Same.
What happened to position number 1? Anybody know?
Your Honor, I waived the appearances.
Oh, that's right. I see 1, 5, and 10.
Yes, Your Honor.
I just saw my note at the same time that I asked that. All right, pretrial, you with me?
I'm here.
Okay,
Hold on.
okay.
Which position?
You gonna call the case? For the
Yes,
record?
position 1, 22 CR 003832C, Alan Arnold. I have a waiver. He's charged at 1 count of simple battery. Offense date June 10th, 2022.
This is a 6th adult cycle of arrest. Last cycle was in March. Interference with government property, 2 counts. 2 counts of criminal damage to property. They may have happened at the jail. That was March 29th. March 22nd, interference with government property, criminal damage to property, 2nd degree. September 2021, failure to appear for ag assault, DV. The case is 21 SC 178327. You got the simple assault, family violence, and the ag assault, of course, that's open. And the 2020 ag assault, a deadly weapon. That's it. He also has an East Point hold.
Okay.
But he's on those other charges without bond. So, yeah.
All right, thank you. Ms. Harmon?
Yes, Your Honor. This is offense date of June 10th, 22 at the Fulton County Jail. The victim, Shadia Bryant, that's Shadiyyah Bryant, is a nurse that works at the jail to provide care to the inmates there. And she was doing what they call a med pass where the defendant was housed. While she was passing, the defendant threw a cup of unknown liquid on her face and body. And obviously he was charged with the simple battery. Your Honor, we do believe that he does present a danger to intimidate this victim. He made an unprovoked attack on the victim that is there to provide care for him. We also are concerned with his reoffense, his risk to reoffend. He has multiple open felonies, multiple cases in which he is in a no bond status. 4 of the cases were alleged to have occurred in 2021. He has 6 open cases from what I looked at in his history. 4 are alleged to have occurred in 2021. 5 of the cases are crimes against another person, which leads us to believe that he won't hesitate in harming another again. And it's telling, if you're committing additional crimes while you're in jail, you really don't have a problem with reoffending. And then of course, the 2021 FTA is concerning that he is, if he would make bail, if he would return to court. So our recommendation is as follows: a $3,500 surety bond, the 1-day anger awareness class, no further contact with the victim unless he's being treated and is medically necessary, no alcohol, drugs, or weapons, nothing further.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Alan Arnold is 18 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here, but he doesn't have any family to assist with any bond. He obtained a GED and he has never worked, Your Honor. Therefore, he doesn't have the means to pay anything toward bond. Mr. Arnold informed me that he has been in custody for the past 10 months. We are denying the allegations today. He is presumed innocent in this case and any open cases. I am requesting a signature bond, Your Honor. He isn't a flight risk. He certainly will not be going anywhere without any bond. And I am opposed to the 1-day anger awareness class, as I am concerned that he will not be able to complete that while he is in custody, Your Honor. If Your Honor determines that he is ineligible for the signature bond, I would ask for a bond of no more than $1,000. Thank you, Your Honor.
All right, I'm going to order a $3,500 surety bond. Gonna order no drugs, alcohol, or weapons while on bond. No further contact with Shadia Bryant. That should be it, correct?
Yes.
Okay, you're not going to order the anger awareness class for the reasons Ms. Gant?
Yeah, I will not order that today.
Okay.
If he's at the jail and that's a nurse, you might want to do no further violent contact, because you never know which nurse is going to what floor.
I've requested that the contact would be no further contact with the victim unless he was being treated.
Okay, don't want to put her in jeopardy. I mean, is there only one at a time, maybe? Because I mean, if he did that, you know, he really.
That wouldn't stop her from going to that floor. That wouldn't stop them from sending her back to that floor.
All right, no further contact with the nurse unless being treated. Is that what your recommendation is, Ms. Harmon?
Yes, and I don't want to craft it in a way that it would prevent her from being able to work at the jail.
Certainly. So, well, you know, it's only with this one victim. I mean, this one defendant rather. So it's not, you know, if that defendant is there, I guess I could have asked the jail. I don't know. There's probably one nurse at a time. I can't imagine. I don't know if there are 2 or not, or on different floors. But he's to have no further contact with her unless he's being treated. I could say no further violent contact, but I don't want the nurse to be in jeopardy either. I'll just say no further, because he shouldn't have any contact with her other than treatment, but was that not the contact before? When he's alleged to have thrown a cup of water on her, I guess she wasn't treating him before. She was just walking by.
It seemed like she was just walking by and he threw some unknown liquid on her.
Well, I can't imagine that he would be nicer because she's treating him. I don't know. You know, kind of a weird situation.
Right.
Want her to be able to work, but I mean, you know, he's not going to be there forever, I guess. I don't know. We'll just say no further violent contact with the nurse. I don't even know if I want to say unless being treated, because obviously she's probably going to do all that she can to avoid him.
Okay.
So let's just say no further violent contact with the nurse.
And we are unopposed to that provision, Your Honor.
Okay, thank you. And I said no drugs, alcohol, or weapons. Okay. All right, position number 5. And that's 22 CR 003743E. Abraham Dominguez. It's charged with 1 count of DUI. Driving under the influence of alcohol. Concentration is 0.08 G or more within 3 hours. Failure to obey signs and control devices, and a 3rd charge of driving, possession of open alcohol container, all with the offense date of June 12, 2022. Pre-trial.
It's his 3rd arrest. Last was 2014 DUI conviction out of Barrow County. Yeah, 2009 driving without a valid license. That's it.
Okay. All right, Ms. Harmon.
Yes, Your Honor. Oh, 1 second. Sorry, my screen is moving. The location was 1465 Holcomb Bridge Road in Roswell. The defendant was alleged to have run through a red light at Market Boulevard and Holcomb Bridge Road in Roswell. So an officer who was there pulled him over for a traffic stop. When the officer made contact with the defendant, he observed slurred speech, the smell of alcohol, and bloodshot, watery eyes. He did administer a breath test to the defendant, and it registered at 0.36 at one point and 0.363 at another when he was tested at the Roswell jail. When they did search the car, they did find an open Michelob Light beer behind the center console of the vehicle. Your Honor, obviously we believe that this defendant presents a danger to the community for clear reasons, operating the vehicle under the influence of alcohol. Also, we do believe that he presents a risk to reoffend. The 2014 DUI conviction is concerning, and that he did have another driving offense in his history, and the history is very limited. So it's only driving offenses in his history. So we do believe that that does present a risk for him to commit more driving offenses. Our recommendation in light of the foregoing is a $3,500 surety bond on count 1. On count 2, we're recommending $500 surety. On count 3, we're recommending $500 surety. No alcohol, drugs, or weapons. No driving without a valid license. Nothing further.
All right. Ms. Gant.
Thank you, Your Honor. Mr. Abraham Dominguez is 33 years old. He has been in the Atlanta, Georgia area since 2003. He has family here, including 2 children, ages 12 and 5. He does pay child support for the minor children. Your Honor, Mr. Dominguez completed high school. He works with his brother in the area of construction, Your Honor. Today, we are denying the allegations. While I acknowledge my client's history, I am requesting a signature bond. If Your Honor determines that he is ineligible, I would ask for a bond of no more than $2,000. That would be $1,000 for the DUI and $500 for each for the remaining offenses, for a total of $2,000, Your Honor. Thank you.
All right. I'm going to order a $4,000 signature bond, I'm sorry, $4,000 surety bond. And with that surety bond, the first charge will be $3,000 on the DUI and then $500 on the other two traffic charges for a total of $4,000 surety bond. I'm going to order no driving except without a valid license from DDS and no drugs, alcohol, or weapons while on bond. Anything else that I need to take up?
Nothing further. Thank you, Your Honor.
Okay. And then let's see, we have position 10. 22 CR 003820E. Antonio James. He's charged with 1 count of theft by taking. Offense date May 12, 2022. Have anything pre-trial?
8 total. Last arrest was back in November. Theft by receiving. Nope, I'm sorry. Last arrest was in the 13th of this month. Went to the city jail for suspended license. Before that was November 2021, theft by receiving. April 2021, FTAs for possession of a Schedule 1 controlled substance and possession of drug-related objects. He was originally arrested for that January 2021. 2018 shoplifting dismissed. 1, 2, 3. He got 3 counts of trespass. He pled NOLO to 1 count of gambling. He pled NOLO to from 2017, 2016 probation violation, and another one in 2016.
Okay. Is this yours, Ms. Brown?
Yes, Judge. Police responded to 227 Peters Street and spoke with the victim in this case, Eric DeFino. That's D as in dog, EFINO. He stated that he left town and while he was away, he observed a person on his camera footage stealing a package. The individual was caught on his security cameras. It was skincare items that he said was taken, valued at less than $1,500. The recommendation in this case for bond is $3,500 surety. Stay away from 227 Peter Street. No further contact with Mr. DeFino. No alcohol, drugs, or weapons, Judge.
Okay. Ms. Gant?
Thank you, Your Honor. Mr. Antonio James is 24 years old. He has been in the Atlanta, Georgia area his entire life. However, he informs me that he does not have any family here. He does not have anyone to help pay bond. He attended high school in Atlanta. He is unemployed. Your Honor, he denies the allegations. We are unopposed to the stay away and the no contact orders. I would ask that Your Honor consider a signature bond, Your Honor, and if Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000. Thank you, Your Honor.
Okay. I'm going to order the $2,500 surety bond. I'm gonna order stay away from 227 Peter Street. Is that an apartment business? Anybody know? No?
I'm not sure, Your Honor.
Okay. I know there's combination of housing and businesses.
Judge, I apologize. I was on mute. It looks like it may have been, he said his front porch, so I'm assuming it may be a residence.
A residence, okay. All right, and no further contact with the victim, Eric DeFino? And no drugs, alcohol, or weapons while on bond? Anything else I need to take up?
Nothing from the defense, Your Honor. Thank you.
All right.
Nothing, Judge.
All right. Have we addressed all of our cases?
Believe so, Judge.
Okay.
Are we ready to go over the calendar?
You sure are.
Who answered the loudest?
Okay, again, the reset date for the SAP calendar is going to be June the 28th. Position number 1 is reset to the SAP calendar with a $3,500 good bond. Position 2 is reset further notice with a $3,500 SOB through pretrial. Position 3 is reset further notice with a $4,000 total SOB through the jail. Position 4 reset to the SAP calendar with a $4,500 good bond. Position 5 is reset to the SAP calendar with a total $4,000 good bond. Position 6 is reset to the SAP calendar with a $2,000 total good bond. Position 7 is reset to the SAP calendar with a $3,000 good bond. Position 8 is reset to the SAP calendar with a $2,500 total good bond. Position 9, I'm showing that it's going to the SAP calendar, and I'm showing that it's going on the June the 21st calendar. Was there any type of bond I needed to put on this? Was a bond issued on position number 9?
I don't know. That was the email from Mr. Jordan.
Okay, I'll check with him on that.
Okay. It
All
may
right.
already be a bond though.
Okay, no problem. Position number 10 is being reset to the SAP calendar with a $2,500 good bond. Position 11 is reset further notice with a $3,500 SOB through pretrial. Position 12 is reset further notice with a $1,500 SOB through pretrial. Position 13 is going to the SAP calendar with a $1,500 good bond. Position 14 is reset further notice with a $2,500 total SOB through the jail. Position 15 is being reset to the SAP calendar with a $1,500 good bond. Position 16 is being reset further notice with a $1,000 SOB through the jail. Position 17 is going to the SAP calendar with a $15,000 good bond. Position 18 is being reset further notice with a $5,000 SOB through the jail. Position 19 is going to the SAP calendar with a $3,000 total good bond. Position 20 is being reset to the SAP calendar with a $5,000 total cash bond. Position 21 is being reset further notice with a $1,000 SOB through the jail. Position 22 is going to the SAP calendar with a $2,500 good bond. Position 23 is going to the SAP calendar with a $2,000 good bond. And position number 24 is going to the SAP calendar with a $2,000 good bond. Are there any corrections, comments, or otherwise?
May I please double check with 23?
Position 23?
Yes.
Okay, for position 23, I have it reset to the SAP calendar with a $2,000 good bond.
Thank you. Thank you.
Okay, are there any others?
Nope, I'm good. Is everyone else clear?
Okay.
All right, see you next time. Everyone have a good afternoon.
Okay, and Judge Dees will be coming right over to you.
All right, thank you.
You're welcome.
All right, bye-bye.
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 Bye.